How's it going, folks? So, I came across this opinion piece today, and this is a prime example of a common thing that gun controllers do. They will make these, you call them apples to oranges comparisons, but that's being incredibly generous to them. More accurately put, would be apples to planets comparison. And this particular opinion piece I found is no different. And I'm going to get off the beaten path a little bit, off the point a little bit, and address the title. And the title is What the Well-Regulated Part of the Second Amendment Means to Me. Well, the fact of the matter is that it's relevant what it means to you. What is relevant is what it means, what was meant by the people who wrote it, who ratified it, who drafted it into law, into the Constitution. That's the important part. And my side of the aisle has addressed the whole well-regulated militia claim tens of millions of times over, and the gun controllers act as if that never happened. They still go back to their same nonsense. They go back to their same petty lies. They don't have anything for it, but that's to be expected from the gun controllers. They have the cognitive abilities of 5-year-olds when it comes to this debate. But on to the main topic, the opinion piece. The person writing this opinion piece is a gun controller. She says it at the bottom in the description. But the article she wrote, she's basically saying that because there were certain stipulations put on her as somebody who serves alcohol, that there should be certain stipulations to people purchasing firearms. And guess what? There already are, by the way. But moreover, this is like an apples to planet comparison. Now, if she had, say, compared people who serve alcohol and compared them to, say, FFLs, that would be a little bit more of an apples to orange comparison. But then again, the system is much more stringent on FFLs. There's a lot more that goes into being an FFL than there does to being a bartender. Case in point, bartender. You have to make sure, obviously, the person who's consuming the alcohol is over 21. Now, if you look at them and can tell they're obviously over 21, you can get away with not carding them. Now, the same cannot be said for an FFL. In fact, an FFL, anytime they want to sell a firearm to somebody, well, there are several things that need to take place. An ID of the buyer must be shown. A 4473 form must be filled out. And that 4473 form has to be kept for their records. The purchaser of a firearm has to get a NICS check performed on them with certain exceptions, as in, like, they're in Texas and they show their LTC. They're golden at that point. On the next check, you still have to see the identification, and the 4473 still must be filled out, but the LTC is good enough to pass the next check, because guess what? You hold an LTC in Texas, a background check is constantly being run on you. And the requirements to get an LTC in Texas are a little bit more stringent than having the requirements to buy a firearm. That being said, the FFL skips any one of these processes. The penalties are much more stringent than, say, for a bartender. A bartender, say, accidentally sells a drink to somebody under the age of 21, well, accidentally or intentionally, um, I guarantee you the penalties for that are a lot less severe than, say, an FFL selling one of these to somebody under 21. Now, I understand that people are going to bring up, well, NFA Title I long guns, you can buy them at 18 if you're not a prohibited person, and that part is true, actually. That, I think, is the only area where they're a little bit more lenient on somebody with firearms than they are with alcohol. You know, with bar hoppers, people who go bar hopping, that would be a more apples to orange comparison with a gun owner or a gun buyer. But even then, gun buyers got a lot more requirements they have to meet than somebody going bar hopping. You know, first off, you don't have to get a background check done on you every time you go bar hopping. The bartender doesn't have to fill out this long form that they have to keep on record for every single person they sold a drink to. Now, do they? As long as you're 21 and you don't have a court order against you specifically saying that you cannot consume alcohol due to a certain crime where alcohol was a factor, then you can legally drink. And even if you have that on you, it's not like the bartender's going to perform a background check on you. Whereas if you're purchasing a firearm, guess what? You either have to have your LTC if you're in a state that allows it, or you have to get a background check done on you, among other things. I also noticed that this person is not advocating for licenses to go bar hopping now, is she? You see, that would be, a little bit more of a apples to orange comparison, but she doesn't want to bring that up. This is a common thing that the gun controllers do quite frequently, whether it be with the license to drive on public roads or, any other thing, like, getting, a library card. Gun controllers always love to make these really false comparisons. And quite frankly, I don't know why that we have any more gun control laws on our books, which is how ridiculous these arguments they make are. You would think that we would wise up and say, you know what, screw this, let's repeal every gun law because they're not working, and the people who are arguing for them aren't making good arguments for them, and all the arguments you could make for these gun laws tend to be really bad. It's more logical to simply not have these gun laws on the books and not prohibit people from the means to protect themselves should they choose. You know, so with that being said, folks, you guys got the comment section below. If I haven't said it before in this video, I'm posting a link to this opinion piece in the comment section. Y'all take it easy out there and have a great day.